Morning, good afternoon, or good evening, depending on your time zone. Welcome to the first Global Experts Plenary in this fascinating biennial online global symposium, Human Rights, Sustainable Development, and the Law 2026. I'm Rayla Puna from the Philippines, Program Manager of CISDL's Climate Law and Governance Initiative, and one of your moderators for this first Global Experts Plenary, linking human rights and climate change through international law.
Hello and welcome. I'm Aditya Prasanna Bhattacharya, a recent LLM graduate of the University of Cambridge, and together with my co-moderators, it's a pleasure to introduce our first chair of this plenary. Advocate Ayman Sharkawi is the highly distinguished and accomplished CISDL lead counsel for climate change, having previously served as legal advisor to the COP22 presidency and a special advisor to the COP23 presidency. He also serves as the deputy chair of the IUCN World Commission on Environmental Law and directs the Hassan II International Environmental Training Center.
Good morning, good evening, good afternoon, everyone. Thank you so much. I'm Zoya Zahid, a researcher at the University of Cambridge, and I'm also delighted to help introduce our chairs, Dr. Ashfaq Khalfan, who chairs the CISDL Board of Governors and is a highly respected and knowledgeable human rights and development law jurist. He's a director in the Global School of Sustainability at the London School of Economics, having previously served as Director of Law and Policy at Amnesty International and as Director of Climate Justice at Oxfam America. He's also published several impressive books, papers, and commentaries on topics related to sustainable development and human rights. Please, chairs, if you may find it, the floor is yours.
Thank you very much. I'm happy we found this virtual floor. Good morning, good afternoon, good evening, depending on your time zone. Thank you, Aditya, for the kind introduction. Welcome indeed to this first Global Experts Plenary. Thank you for joining us. It is a privilege to co-chair this first plenary alongside my dear friend and colleague Ashfaq on a question that sits at the heart of what this symposium honors. Judge Weeramantry, in his writing from the International Court of Justice, insisted that environmental protection is not separate from human rights doctrine, but essential to it, a precondition, in effect, for rights as fundamental as health and life itself. That insight, once considered ahead of its time, found its fullest echo just last year, when the International Court of Justice, this time speaking as a full court, unanimously held that a clean, healthy, and sustainable environment is a precondition for the enjoyment of many human rights. And Judge Gonthier, whose memory we also honor today, embodied the values that give that doctrine its moral force: responsibility, fraternity, and sustainability. A legacy he carried in his final years as chair of the board at the very center convening us today. That inheritance shapes the different parts of my own work as lead counsel on climate change at the CISDL, working through, for example, in particular, the Climate Law and Governance Initiative. I see this doctrine advancing daily in advisory opinion, in litigation, and in the diplomatic language states use or resist using sometimes at the negotiating table at various COPs. As deputy chair of the IUCN World Commission on Environmental Law, I see it tested and refined across a global community of jurists and practitioners. And as director of the Hassan II International Environmental Training Center in Morocco, from where I'm speaking to you, I see another half of it, the work of translating doctrine into training capacity and lived practice for the communities who will carry it forward. Often those have contributed least to the crisis they now face. Today's panel brings together some of the world's foremost voices on how international law is responding through evolving human rights jurisprudence, through the advisory opinions reshaping states' obligations, through litigation pushing the boundaries of accountability, and through the sustainable development goals that remain our shared roadmap. We have assembled an extraordinary group of experts to help us navigate these questions, and I look forward to a rich and rigorous exchange over the next hour. Thank you. Dear Ashfaq, the floor is yours, if you can find it as well. We can see you very well.
I'm sorry, I'm some technical difficulties, but yes. Well, it's a real pleasure to be with you all, and I'm glad to be co-chairing this with Ayman. I would now like to pass on to our first keynote, who is Professor Sumudhu Attapattu, who is joining us from Sri Lanka actually today. She's a globally recognized teaching professor and director of the Global Legal Studies Center at the University of Wisconsin-Madison. And she's the CRCL lead counsel for one of her programs on human rights and poverty eradication. She's a preeminent scholar of international human rights law, environmental law, and climate change, and has authored many influential books and articles on these topics. So she's kindly agreed to speak for about 5 to 8 minutes, and I'll turn the floor over to you, Samadhi.
Oh my God.
Now, I know there's been an issue of power outages, so I'm hoping that's not affecting her right now.
Luckily, we do have power right now. So thank you so much, Ashwak. I just couldn't get the audio to work somehow. Can you guys hear me?
Yes, we can.
Okay, great. So greetings from Sri Lanka. So I was asked to speak for about 5 to 8 minutes, shorter the better, Ashwak said. So I was thinking back to the Inuit petition and how far we have come since then. So that was in 2007 when the Inter-American Court of Human Rights said that it could not really hold the US accountable for causing climate change. At that time, US was the highest contributor to climate change. But now we have this incredibly powerful advisory opinion from the International Court of Justice, which endorsed the link between human rights and climate change, environmental issues in general, which gave a huge boost to the UN General Assembly resolution on right to a healthy environment. Not only did the ICJ endorse this link, but it also said states have an enhanced due diligence obligation to protect the climate system. So I want to use the time I have as an invitation to several constituencies that are present here. The first one is to legal practitioners and NGOs, because I think we have now entrenched the link between climate change and human rights, but I think we have a long way to go as well, right? So the ICJ endorsed the erga omne nature of climate obligations, right? It also said the state responsibility principles are wide enough to cover climate change. So what does this mean? We know that climate litigation has increased quite a bit, but we have not really had many cases trying to hold the major emitters, especially fossil fuel companies, accountable for causing climate change. So how do we use the ICJ decision, advisory opinion, especially the erga omne nature of climate obligations and state responsibility principles in novel ways to hold these major companies major emitters accountable, who are still amassing billions and billions of dollars in profits. The second group is to educators in general and academics. How do we use the advisory opinion in our teachings, especially on climate justice? So the court did not specifically go into climate justice, but some of the separate opinions did, especially Justice Hilary Charlesworth. So what is the link between right to healthy environment and climate justice? How do we use this advisory opinion to help especially marginalized and vulnerable communities and states? And I think as law professors, I think we have an special responsibility to teach climate change, incorporate climate change into whatever we teach. It may be property, it may be constitutional law, it need not be just environmental law or separate course on climate change. Those are great, but I think the time has come for us to incorporate climate change into everything we teach. Use this in our writings, in our publications, in our teachings. The third constituency is policymakers and lawmakers. As we know, they play a huge role, and climate change has become highly politicized, especially in the country where I live, in the US. To be bold, to take a long-term view of development and not be bound by election cycles. As we know, policymakers are more worried about the next election cycle than climate change. But I think we have come to a point where we cannot ignore this anymore. And the final group that I want to talk to are the students. And I'm hoping that there are lots of students in the audience today. I invite you to learn as much as possible on climate change, especially read the advisory opinion from cover to cover. And the Inter-American, I should also mention the Inter-American Court advisory opinion. That was fantastic. Please read those very, very carefully and learn as much as possible on climate change, because I think your future depends on it. I think I used 6 minutes, so I will stop there. And in terms of the biggest challenges I see are political and financial power of these fossil fuel companies. Yeah, I will stop there. Thank you so much.
Thank you. Thank you very much, Professor Atapatu, for both those compelling remarks as well as your very impressive timekeeping. Very well done. Your remarks set the stage beautifully for our conversation, and we have 4 focused questions to discuss next in this plenary, reminding each of you to also type questions for the speakers, the experts, that again, we are very happy to have with us into the question and answer segment of the platform, the online platform that you're using. Please specify while you do so your name and country. So those 4 questions in particular, the plenary will be focusing on 1, how does human rights law respond to the climate emergency? Second, how does international law on climate change and human rights advance the global sustainable development goals and the post-2030 agenda? Third, what have been the most recent developments in climate litigation worldwide, including in efforts to transition away from fossil fuels? And fourth and finally, what are the most promising opportunities going forward? Thank you. Back to you, Ashfaq. Ashfaq, you are currently muted. Apologies. I can see you well again, but you are muted.
Thank you. Thank you. So just to introduce our speakers, and as I do that, I think you'll hear a bit about the story about some of the development of human rights and climate change and the links between them. So our first speaker is Honorable Justice Professor Marcel Szabo, who is a Justice of the Constitutional Court of Hungary and a professor at Pázmány Péter Catholic University. Now, he has also served as the Ombudsman for Future Generations in Hungary, which was one of the first ombudsperson institutions established to advance the rights of to advance future generations. He is also laureate of the Weeramantry International Justice Award. Our second speaker is Professor Payam Akavan, who is a senior fellow and human rights chair at Massey College at the University of Toronto, a fellow of the Royal Society of Canada, and a member of the Permanent Court of Arbitration in The Hague. Now, he has served as counsel to the Commission of Small Island States, and there was a question in the Q&A in the opening panel about small island states. So the colleague who asked that question from Mauritius, here's your answer. So he's served as a counsel for the Commission of Small Island States on international law, and including in making representations for certain countries, I believe Bangladesh and others, before the International Court of Justice in their advisory opinion on climate change. Sumudu corrected herself from advisory opinion, from decision to advisory opinion, but I actually think that we should actually consider a decision. Certainly, the International Law Commission will be treating it as a decision, as a source of law. Many domestic courts and lawyers around the world will be treating it as a source of law. Our third speaker is Professor Tanya Kiriazi, who teaches at Middlesex University in Dubai, leading the Law and Politics faculty. She's an associate fellow of the Center for International Sustainable Development Law and a rapporteur for the International Law Association Committee on the SDGs. So her cutting edge research is on the intersection between environment, climate, and human rights. And she's the founding president of the ILA's branch for the UAE. We then have Professor David Boyd, who teaches at the University of British Columbia and served as the UN Special Rapporteur for Human Rights and Environment from 2018 to 2024. And so, again, in terms of the history of the development of this, I don't think we'd have had the recognition of the right to a healthy environment, the right to a clean, healthy, and sustainable environment if it hadn't, without David's work, which was foundational in terms of setting up the basis for this and for the eventual recognition of this right by the Human Rights Council and the General Assembly. So each of these speakers are speaking for 4 to 5 minutes to participate, to permit more rounds of engagement. So yes, and people participating online, please do ask questions as you hear, as they arise for you, with your name and country, as our speakers give their presentation. Back to you, Ayman.
Thank you very much. So, Honorable Justice Professor Elsek Szabo and Professor Bayan Akavan, let's turn to you both first in response to the 4 questions I outlined in my previous intervention. Honorable Justice Professor Szabo, if you'd like to go first, please go ahead.
Thank you very much, Mr. Chair. It's a great honor to participate in this distinguished panel. Today, I would like to share one particular experience from the jurisprudence of the Hungarian Constitutional Court, which may also have broader relevance for international environmental law. More than 30 years ago, in 1994, the Hungarian Constitutional Court adopted what later became known as the principle of non-regression in environmental protection. The court held that where the legislature has already established a certain level of environmental protection, the state cannot simply lower that level without a constitutionally compelling justification. At that time, this was essentially a static constitutional obligation. The constitutional benchmark was the existing level of environmental protection. Any unjustified step backwards was regarded as unconstitutional. The doctrine anticipated what later became a much more widely recognized principle in international and comparative environmental law. However, climate change has fundamentally transformed the constitutional landscape. The challenge today is not merely to preserve yesterday's level of protection. The challenge is that scientific knowledge itself is constantly evolving. This requires constitutional law to evolve as well. In our recent climate judgment, the Hungarian Constitutional Court therefore developed this earlier doctrine further. The court drew inspiration from the famous Gabčíkovo-Nagymaros project judgment of the International Court of Justice. In that judgment, the International Court of Justice recognized an important idea. International legal obligations cannot be interpreted in isolation from changing scientific knowledge and changing environmental realities. The court acknowledged that developments over time may fundamentally alter the factual context in which legal obligations operate. This is sometimes described as legal obligations being overtaken by events. It was actually the construction of Nagymaros Dam which was overtaken by events in that decision. Inspired by this reasoning, the Hungarian Constitutional Court concluded that constitutional environmental obligations are likewise dynamic rather than static. A legal framework that was entirely adequate 20 or even 10 years ago may no longer satisfy constitutional requirements if scientific knowledge has substantially advanced. This is particularly true in the field of climate change. The precautionary principle requires constitutional institutions to learn from science rather than merely react to environmental damage once it has already occurred. As climate science develops and as precautionary principles calls for earlier and more effective action, constitutional standards must also develop. In other words, constitutional review cannot ask only one question: has the state stepped backwards? It must also ask, has the state kept pace with scientific knowledge? This transforms the very meaning of non-regression. Non-regression is no longer simply a prohibition against dismantling existing protections. It also becomes a constitutional obligation to reconsider earlier regulatory choices in the light of new scientific evidence and emerging environmental risk. I believe this approach illustrates how constitutional and international law increasingly speak the same language. Both recognize that environmental protection cannot remain frozen in the time while nature itself is changing at an unprecedented pace. Perhaps the greatest constitutional challenge of the climate era is that the stability of constitutional values requires dynamism in constitutional interpretation. Ultimately, the Constitution protects not only today's environment, but also the environmental conditions upon which the dignity, health, and the freedom of future generations depend. Thank you very much.
Thank you very much indeed, Honorable Justice Professor Marcel Szabó. Now happy to give the virtual floor to Professor Payam Akhavat.
Greetings and apologies that I'm reaching you in transit to London Heathrow Airport, which explains much of how my life is spent. I'm really very honored to be part of this distinguished panel, and I wish to just briefly pay tribute to Judge Weeramantry, who I had the privilege of knowing, and it is remarkable to look at the Gabčíkovo-Nagymaros jurisprudence, the separate opinion of Judge Weeramantry, and the year before that, in 1996, his remarkable separate opinion in the Nuclear Weapons Advisory opinion. And we bear in mind that this was the decade in which the UN Framework Convention on Climate Change was adopted, at a time when perhaps unlike today, we had yet to feel the catastrophic effects of climate change. And I say this because I wish to perhaps, in the few minutes that I have, share with you the motivation of the small island states, the smallest of nations on Earth, in exercising remarkable global leadership in making possible both the ITLOS and ICJ advisory opinions, and then perhaps to reflect briefly on the significance of framing the question of climate change as a human right. To begin with, and going back to the moment in 1992, when the UN Framework Convention is adopted, and then fast forwarding to the Paris Agreement in 2015, based on the best available scientific evidence, it was unanimously accepted by the Intergovernmental Panel on Climate Change that temperature rise must be kept within 1.5 degrees Celsius above pre-industrial averages in order to prevent catastrophic harm. And that goal, of course, for climate vulnerable states, especially small island states, has very real existential consequences. And sadly, today, based on the existing nationally determined contributions of states parties to the UN Framework Convention and their actual policies, which fall short of even those grossly inadequate NDCs, we are on track to achieve a temperature rise of almost 3 degrees Celsius. And it is no exaggeration to say that that is a death sentence for many small island states. The two founding members of the commission, which requested the advisory opinion from ITLOS, include Antigua and Barbuda. And we know that in 2017, Hurricane Irma basically obliterated the entire island of Barbuda. Its entire population had to be evacuated. The entire island had to be rebuilt. And in the even more catastrophic circumstances of Tuvalu, a UN member state with a population of some 10,000 indigenous people, it is likely that within a generation that will simply become uninhabitable, and that in the foreseeable future, it will, like other small island states, simply disappear under the waves of the Pacific Ocean. So it was the failure of the consensual process under COP that motivated these small island states to move away from the language of policy and discretion to identifying the legally binding obligations of states to prevent this catastrophic harm. The point was made also by Dr. Khalfan that although these are technically non-binding advisory opinions, they are authoritative statements of binding international law. So it's misleading to simply dismiss them as advisory opinions, not least when the 21 judges of ITLOS and the 15 judges of the ICJ adopted those opinions unanimously, which is quite remarkable. Now, if we look at the content of that jurisprudence, and of course, we also have the Inter-American Court of Human Rights, which also delivered a remarkable opinion, which has been referred to, and now we have the case before the African Court of Peoples and Human Rights. The framing of these issues in terms of human rights is, of course, significant, but I would say that the customary law principle of transboundary harm is even more significant. Because if we look at human rights essentially through the prism of the obligations of states vis-a-vis their own populations, and we consider the circumstances of climate vulnerable states, we see that they are placed in a position where they are not able to respect the right of their citizens to a clean and healthy environment because of the conduct of other states, in particular, the major polluters. So the transboundary elements of transboundary pollution, I think, remains perhaps the most important dimension of this jurisprudence. And if I may just conclude by saying that the question which the small islands put initially to ITLOS and then to the ICJ is remarkable in its simplicity. The principle of transboundary harm is nothing new. It was well established as long ago as the famous case between the United States and Canada, the Trail Smelter case. The only novel aspect was the application of that principle to the context of climate change in light of the uncontested scientific evidence. So the question now is, how can this jurisprudence be used, whether within the COP process to reframe negotiations, or perhaps in the context of contentious proceedings at some point in the future before the ICJ or ITLOS, or of course in litigation before domestic courts, and certainly in common law jurisdictions, customary law is directly applicable, and there are already proceedings, let's say before the Supreme Court of Canada, which is invoking this jurisprudence. So I will end by once again thanking the organizers for allowing me to share these observations, and I apologize once again speaking at the back of a cab on my way to the airport, and I wish you all the best in your deliberations.
Thank you very much, Professor Akawal. And of course, we heard you very well, so that all worked out perfectly well. So we've heard about dynamic constitutional interpretation and the need to look differently at international law, taking account of transboundary harm. So that's lots of food for us to chew on, especially if we put those two things together. I'll move on to the next two speakers, sorry. So Professor Tenya Kyriazi, over to you, please.
Thank you very much, and thank you for inviting me to contribute to this panel. My perspective comes from my role as co-rapporteur of the ILA Committee on the contribution of international law to the Sustainable Development Goals. So I will address the questions as briefly as I can within the time frame through this lens, and I will make 4 main points. So the first point is that climate change has changed the way that we understand human rights law and the way we understand state obligations that derive from it. Human rights law responds to climate emergency by defining legal obligations, and climate change affects the rights to life, health, food, water, housing, education, and a clean, healthy, and sustainable environment. It also affects these rights unequally. Those who contributed the least to climate change often suffer first and most. People in poverty, women and girls, children, indigenous communities, persons with disabilities, migrants, and communities in small island and climate vulnerable states. Human rights law contributes principles that climate law alone cannot provide, such as equality, non-discrimination, participation, accountability, access to justice, and the protection of vulnerable groups. It also brings to the forefront economic, social, and cultural rights. And this is why SDG 13 cannot be implemented independently of SDG 1, SDG 5, and SDG 10, for example. My second point is that the biggest legal development that we have is integration. In the context of our work with the ILA committee, we did a mapping exercise that demonstrates that every SDG is already reflected somewhere in international law. The challenge, therefore, we found is not the absence of law, but its fragmentation and how it can be interpreted and applied coherently. Human rights law, the Paris Agreement, biodiversity law, trade law, investment law, and the law of the sea should be interpreted coherently. A good example of that is SDG 5, where, of course, human rights law instruments require women's effective participation in decision-making and the elimination of discrimination. And this means that measures, climate governance measures, adaptation, mitigation, loss and damage must be gender responsive and inclusive. My third point is that climate litigation has entered a new phase, and I think the previous speakers all discussed that in more detail. Climate litigation has become one of the most important areas where the integration is taking place. Climate litigation is moving from asking whether governments should act to defining what governments legally owe. The last 2 years have been remarkable. We mentioned key developments, including the European Court of Human Rights, Inter-American Court of Human Rights, the ITLOS advisory opinion, the ICJ advisory opinion, and I'd like to add to those the general comments and recommendations of international human rights treaty bodies and special procedures. The trajectory then for us is clear. Climate action is increasingly being translated into legal obligations. So that's it, the optimistic kind of silver lining. My fourth point is that the future is implementation. A just transition goes beyond reducing emissions. It requires social protection, gender equality, climate finance, technology transfer, debt justice, support for developing countries, and protection of affected communities. A transition that reduces emissions while increasing poverty or inequality cannot be regarded, obviously, as sustainable development. Now, the challenges that we have relate to coherence, implementation, and accountability. We need to address this fragmented climate action, mitigation without human rights safeguards, energy transition without gender equality, finance without equity, adaptation without participation, development strategies that leave the poorest and the most vulnerable behind. There is still fragmentation of international legal regimes. Climate finance and implementation, there is a gap between climate finance and implementation because law is moving faster than finance. Current and recent Geopolitical tensions are also affecting multilateralism, so international cooperation is weakening, and the appetite for that is weakening, and now it is needed the most. And we translating commitment, and the biggest challenge that I think are mentioned already, translating commitments into domestic implementation. States have made commitments, but implementation remains uneven. At the same time, and I'll close with that, there are opportunities. The silver lining is the emerging paradigm of the interconnectedness of international law that we've seen through the recent case law. That was very much evident in the ICJ advisory opinion that relied on the principle of systemic integration enshrined in the Vienna Convention on the Law of the Treaties. Human rights law can ground climate action on international obligations, render it a normative obligation, make it more inclusive and more effective, and international courts and human rights monitoring bodies help clarify what states must do to get there. Thank you.
Thank you very much, Professor Kyriazi, and I'll turn to Professor David Boyd.
Thanks very much, Ashfaq. And it's just absolutely a pleasure to be on a panel with such amazing colleagues. Thank you to CISDL for putting this event together. Friends and colleagues, I think we have to take a big picture perspective on this. And if you look at the progress that we have made in terms of the law's development over the past decade, it's absolutely extraordinary. From the Paris Agreement to the recognition of the right to a healthy environment by the Human Rights Council and the General Assembly, to the advisory opinions, which we all participated in and should celebrate, and to the ICJ's, the world's highest court, making that powerful advisory opinion, which was catalyzed not only by the small island states, but by a group of students from the South Pacific. I think it's important to reflect on that tremendous progress in the law over the course of a very short period of time. At the same time, we also know that the climate crisis is worsening. And one of my great pleasures as UN Special Rapporteur was having the opportunity to visit countries around the world. But that also came with a dark cloud because people on the ground, whether it was in Botswana, Chile, the Maldives, Portugal, these people are suffering terribly from the climate crisis. And that's why it's so important to take a human rights-based approach, because it puts a human face on this crisis. And so for all of the developments that we've made on paper in the law, we still have tremendous work ahead of us, as Professor Kyriazi said, in the implementation and enforcement of the law. And so there is still much work to be done. I think there are tremendous opportunities. I think we're kind of in a lull right now between the publication of these extraordinary advisory opinions and the cases that will build on those. So cases using the right to a healthy environment to hold states accountable, cases challenging the literally trillions of dollars in perverse subsidies that are accelerating the climate and biodiversity and pollution crises, when those funds should be reallocated to the sustainable actions that we need to solve these challenges. Cases challenging states' failure to utilize the maximum available resources to fulfill their human rights obligations. So there are a wealth of opportunities to use human rights-based approaches to tackle the triple planetary challenge. And I know there are colleagues amongst us who are working tirelessly to do that. I also want to address the question related to the Sustainable Development Goals. I did a report on the SDGs when I was the Special Rapporteur, in which I tried to make the case that these are not political aspirations. The Sustainable Development Goals are based on a rock-solid foundation of international human rights law, which makes their fulfillment obligations in a legal sense rather than options in the political sense. And so that's in response to the second point. And I also think that, turning away from the law for a minute, I think we're also living in a period of extraordinary change in terms of technology and energy. And as dark as the climate crisis may seem, we often lose sight of the fact that we have made extraordinary progress over the last 20 years in renewable energy. And this is truly changing the world. It's changing the energy systems of the world. So one quick example is solar electricity. In the year 2001, there was 1 gigawatt of installed solar electricity generating capacity. By the year 2012, we had reached 100 gigawatts. By the year 2022, we had reached 1,000 gigawatts. And this figure doubles every 2 to 3 years. So we're now at about 2,500 gigawatts of solar capacity. What does that mean in practice? It means, for example, that in the European Union, renewables now produce more electricity than coal. In China, we've seen tremendous progress. In Pakistan, in the Philippines now. Solar, if it maintains its current rate of growth, will surpass coal by 2030, just 4 years from now, which is something that nobody could have foreseen 15 or 20 years ago. That's very positive news. So the technologies exist to address the climate crisis. Renewable energy, the electrification of everything from transportation to heating and cooling to cooking. These solutions, heat pumps, induction stovetops, electric transportation, the solutions exist, and we as lawyers need to use the law to push forward the adoption and implementation of these solutions as quickly as we possibly can. A couple of examples from around the world where this is happening in very powerful ways. In Australia now, electricity generated by the sun has become so cheap that in 3 Australian states, electricity is actually free for 3 hours a day. In California, they have reduced the use of natural gas 60% in 2 years. And that's largely because of the increase in solar, the increase in wind, and the next major development, which few of us talk about, which is the rapid decline in the price of batteries, the rapid increase in the capacity of batteries to store electricity. So that combination of renewable electricity and batteries has the potential to completely displace fossil fuels for electricity generation. So we're on the cusp of these extraordinary changes in our energy system. The World Bank is investing in solar energy in Africa, which will bring electricity to people for the first time in their lives for 300 million Africans by the year 2030. That has profound consequences, not only for their quality of life, but for the achievement of the Sustainable Development Goals. So I'll stop there. I know this is just our first round, but just wanted to inject a note of optimism into the proceedings. Thank you very much.
Thank you. And what a round it's already been. And thank you also for injecting that dose of optimism. Much appreciated. Thank you to both of you for those stimulating conversations. It is now my great pleasure to introduce our other keynote speaker, Professor Elisa Morguera, currently serves as the United Nations Special Rapporteur on Climate Change and Human Rights, appointed to this role in 2024. She's a professor at Durham University and a renowned expert in international environmental law, particularly on issues of biodiversity, the rights of indigenous peoples, and the human rights dimension of climate action. I said particularly, of course, not only. Her inspiring insights will offer us a unique vantage point on where this field is heading. In 5 to 8 minutes, Professor Morguera, the virtual floor is yours. Thank you.
Yes, thank you so much. It is indeed a pleasure and an honor to be in this distinguished company and to reflect together on challenges, on very profound reasons for optimism, but also on keeping a very, I think, clear sight about the challenges ahead. And I think for how much I feel a shift in awareness, in hope, in action around the advisory opinion, I also can't help but observe the pushback that we've seen politically at the international level in multiple fora, including human rights fora, at the national level around a lack of political willingness to comply with the legal clarifications of all these 3 courts, and the fact that those 3 courts had such aligned complementary findings. So what does that mean? I think that means that there's a shift in mindset around the role of human rights in climate action. That clarification across all courts, the human rights are applicable. The whole body of international human rights law is applicable to climate action, means that we can't content ourselves with better human rights safeguards in climate action. We need those, but we know that, first of all, the idea of safeguards means that human rights are seen as an add-on and something on the side, as opposed to something central to climate action. And we know that the practice on the ground is that of a tick box approach to safeguards. So there's a change in institutional and current practices in terms of really living and breathing a human rights-based approach. But there's also a conceptual change that we need all to support, and that is the human rights are not an add-on to climate action. The human rights must be central in understanding what kind of climate action is more effective for planetary health and human well-being, and which areas of climate action and finance are instead going in an opposite direction. And if that is the case, there's no human rights safeguards that can help us going faster in the wrong direction. And this, in a way, means moving away from overlooking an understanding of the systemic relevance of those repeated patterns of human rights violations that we see on the ground, particularly of indigenous peoples, particularly of peasants, small-scale fishers, and pastoralists, who not only are the most affected by climate change, but are also facing negative human rights impacts from climate action, including in, for instance, large-scale renewables project, including in energy transition, minerals mining, and unfortunately many other areas of climate action, including carbon markets. Now, why is that the case? Because I think we still tend to see the climate issue and climate law as a very technical area, which is mainly about technological fixes, and where we don't recognize the lived experiences of those who are at the front line of climate change, but also of human rights harming climate activities as a glitch to be fixed, as opposed to our deepest source of understanding of where our climate action is misaligned with climate science, with planetary health science, with human health science, and therefore is not aligned with those key clarifications from all the three advisory opinions about the fact that protecting the climate system means protecting all interconnected life-supporting systems. The climate action is not just about carbon, it's about protecting nature, the ocean, and the health of the soil, and their interconnected relationships with every dimension of human well-being that is protected by international human rights law. So what does that mean in practice? It means that that need to phase out fossil fuels, and in fact what I have been calling for in my own work is defossilization of our entire economies is the number one climate action, both for adaptation, for mitigation, and for preventing and responding to loss and damage, that needs to be prioritized, because that is the root cause of the multiple symptoms of violations of human rights, not only the localized ones, but in fact the global ones, the violations of everyone's human right to a healthy environment, to health, to water and food, that we are seeing and documenting more and more in every region of the world. Although we do have regions and countries who have been bearing the brunt of those human rights harm for more than a decade. And what that means very specifically is that, for instance, in international climate negotiations, we can't accept ongoing negotiations that do not prioritize, name, and provide very detailed action on phasing out fossil fuels, not only in the energy sector, but crucially in food systems. And why is this important is because despite the progress, the technological and financial progress that makes reliance on fossil fuels in our energy systems a nonsense, we are seeing still an expansion of fossil fuels in our food systems as fossil fuels for large-scale agriculture, aquaculture, and fisheries, but crucially as fossil feed for petrochemicals, for plastics, fertilizers, and pesticides, which not only fill all of our food with toxic chemicals, most of which we're not even aware of, and which are leading to increasing health impacts, including increasing rates of cancer in younger and younger people, increased obesity and non-communicable diseases, but they're also affecting in so many ways that livability of our planet. There's the direct greenhouse gas emissions, there's the toxic pollution, there's harming forests, oceans, and soils in ways that not only will prevent those interconnected life-supporting systems from regulating the climate, but will always make these areas unable to feed us with nutritious food and sufficient food. And what that will mean in terms of compounding human rights impacts in the context of a worsening climate crisis. For me, the reason for hope is that we're seeing where fossil fuels have been hiding in plain sight much more clearly than we've ever had. And we need to really rely on all these areas of sciences to convey this to taxpayers, to voters, to really see, look at where your public money is going. Look how many times over we're subsidizing fossil fuels while they're not only worsening the climate crisis, but they're using our own health as expendable. And they're accumulating land and market power in ways that in and of itself, even if we were not in a climate crisis, is a huge source of food insecurity. And all of us, I think, are already much more connected than we've ever been. I think the children's rights movement, the youth movements, the health movements, all of them are ready to work with all of us to help make that clarity of understanding of what's at stake in implementing those advisory opinions. And ideally also framing this in terms that comprise but go beyond the climate crisis, really looking at this as a human health crisis, as a food and water crisis, that it is in our power right here and now to address and reverse. Thank you.
Thank you very much, Professor Morgera. So it's an interesting juxtaposition, the hope that Professor Kyriazi and Professor Boyd have provided, and the challenges still ahead. So I think it nicely gives a balanced perspective. I'll now turn to our interveners. First, I'll turn to Alexander Ramdas. Alexander is an associate fellow and at the CISDL, and he's an expert member of the Caribbean Bar. His research interests include climate litigation, international environmental law, and sustainable development in small island states. So I'll turn first to Alexander and then to the questions from Maria Jose. So Alexander, please.
Hi, everyone. It's a pleasure to be on panel with all of you. I've read a lot of your papers over the years, and it is a bit of a surreal moment. But I have two questions. As an attorney practicing in the Caribbean, I have a bit of a different perspective of small island states in their relationship with climate change. I think on the international level, we as the Caribbean are sort of viewed as victims. And I as somebody practicing domestically in the Caribbean, I take a lot of qualms with the actions of our own government. Our own governments. Take, for example, the initiators of the advisory opinion against the International Tribunal of the Law of the Sea. They capitalized on Hurricane Irma as a means of displacing indigenous Barbudans. So my first question is, how do you foresee the use of these advisory opinions and the jurisprudence within them domestically, particularly in countries of the Commonwealth Caribbean, where we've had a bit of a tenuous relationship with international law and the ways in which we incorporate international law, in particular advisory opinions, into our jurisprudence. I draw, for example, the Inter-American Court, when the Inter-American Court found that the death penalty was a breach of the right to life. Trinidad pulled out of the Inter-American Court's jurisprudence the next day. Supervision the next day. So how do you foresee the use of these advisory opinions in Commonwealth Caribbean jurisdictions that have had a very tenuous sort of relationship? And my second question is on the due diligence obligation to regulate private actors. And I would like to get your thoughts on what does that due diligence obligation look like? Or how do you foresee this being actualized? Because, for example, in Guyana, there was a recent decision called Collins and White against the EPA, where it was a decision challenged by environmental defenders, saying that Exxon had, according to their agreement with Guyana, opted to take an unlimited parent company guarantee in relation to oil spills for its subsidiary companies. And the government of Guyana, for some reason, decided in the case to support Exxon. and not the defenders who I mean, the region, Guyana stands to benefit from Exxon having an unlimited parent company guarantee. So how do you foresee that due diligence obligation being actualized?
Thank you. And so our other intervener is Maria Jose Alacon. She's a Seattle Associate Fellow, doctoral researcher at Duke University, focusing on climate change and human rights, and she also coordinates the Global Youth Council on Science, Law, and Sustainability. Now, she actually had to leave because of supporting a relative with actually a heat-related emergency. So it's it's just another example of how everybody is being affected. And she asked that for some attention to the issue of ergo omnes obligations to the international community as a whole, and how states that aren't necessarily directly injured, how can they invoke responsibility in a real way, and how can that get traction in interstate claims or human rights treaty bodies and the courts? Now, so speakers, I think we'll probably take a few audience questions as well. So you'll have a lot of things to try and address. So Ayman, I'll pass to you for that, please. Oh, you're on mute. Or is it going directly to... Sorry, Ayman, I think you're on mute.
Sorry, yes. Sorry, I missed the last 30 seconds. I was handling something operational here. Apologies.
So we'll, I think before the speakers respond, we'll ask the online moderators, Raila, Aditi, and Zoya.
Yeah.
They would like to share some questions.
Indeed. And I would like to also seize the opportunity to remind our brilliant panelists and speakers and experts that they can also leverage the Q&A functionality to answer directly to some of them. But in any case, warmest of thanks to all our interveners for the comments, and again to our experts. And I know that Raila, Aditya, and Zoya have been especially monitoring our online forums for questions. We are happy indeed to take a full round of questions and turn back to speakers if to the extent that time allows us to. So Raila, Aditya, and Zoya, would you like to share some questions from our online audience? Thank you. Raila, you're currently muted. We can see you very well, but you're muted.
Oh, sorry. Yes, thank you, Advocate Ayman. We do have a lot of great questions from the participants. We tried our best to synthesize them so we can get to a lot more. So first, from Muhammad from Pakistan, Omar from Lebanon, and Mehdi from Bangladesh all have a question related to state accountability. In light of the accelerating climate crisis, are existing international legal institutions and mechanisms adequate to hold states and other major emitters accountable? If not, what legal developments or reforms are needed to create a more effective and enforceable international climate governance framework? The second question, Rafia and Rimsha from Pakistan and Etinosa from Nigeria have a question on climate justice and vulnerable communities. How can international law and human rights frameworks better protect vulnerable communities, particularly women, children, and low-emitting countries that bear the greatest impacts of climate change, and ensure that climate finance and loss and damage support reach affected communities in a timely, equitable, and accountable manner?
Thank you, Raila. Our third question is from Ibrahim from Nigeria, Kevin from Kenya, Andre from France. They've all asked what the measurable impact of access to justice has actually been on environmental governance, and what any of it delivers at the grassroots for people who are losing land and livelihood for a crisis that they did not cause. The fourth question comes from Bukhari from Mali, Asim from India, Zara from the UAE, Marjan from Iran, and Jessica from China. And they seek your perspectives on how green industrialization and climate justice can be reconciled in developing countries when emissions are still rising with growth and the influence of the fossil fuel industry, which has outrun the mechanisms which were designed to constrain it in the first place.
Well, speakers, I know these are very difficult questions. So We'll give each of you an opportunity to respond to those that you feel you're best placed to respond to. I'll start maybe with Sumitra, Professor Atwatu.
Thank you. Yes, Ashok, these are very hard questions to grapple with. But one of the points I would like to make is that we seem to be making the same mistakes we did with the brown economy, with the green economy. Elisa actually referred to this in her remarks that, with solar energy projects, especially with wind energy projects, we have been affecting especially indigenous communities. So I think that's where the human rights framework comes in particularly useful, because states are required to fulfill their human rights obligations when it comes to these green energy projects as well. So giving effect to the free, prior, and informed consent principle. I mean, I don't think we are in want of any new principles. It's a matter of implementing the existing principles, which were endorsed by the ICJ and the Inter-American Court as well. So not make the same mistakes we did, learn from the past, which we don't seem to be doing, and also take a look at the underlying reasons why we ended up with the climate crisis, right? And it's the same communities that have been affected by centuries of colonization and colonial policies, imperialism, that are being affected by the climate crisis today. So what does that mean? What are the connections? I think unless and until we look at these underlying reasons, we cannot really address the climate crisis. We are only putting a Band-Aid on the problem. So I think there are lots of big questions to answer, but we also have developed, as David pointed out, very important tools. We have advanced quite a bit. We know what to do for the climate crisis. It's just that we are not doing it, right? For political and other reasons, we are not doing it. So I will stop there and let others comment as well.
Thanks. Sorry, and we also had some questions that Zoya was compiling. So Zoya, please, if you could just share those as well.
Yes. To quickly ask, Dr. Abdul from Senegal, Omar from Lebanon, Arushi from Zambia, Moses from South Sudan, and Betel from Turkey were basically asking about how we can make enforceable climate obligations by ensuring that we move beyond non-binding advisory opinions and moving towards maybe more private actor enforcement techniques as well, such as mechanisms of climate finance or climate adaptation technologies. That is one. And second, Lydia from Belgium, Meena Hill from Pakistan, Kenneth from Nigeria. And they were asking about how we combat strategic litigation against public participation, such actions to protect, basically to remove barriers that prevent climate justice, and also to protect indigenous knowledge and strengthen public health.
Thank you. So the rest of the speakers will probably only have a couple of minutes each. So try and please give you a challenge to try and answer as many as you can. Justice Sabo.
Thank you. I think climate change challenges the traditional territorial model of international responsibility, because emissions cross borders while legal jurisdiction often doesn't. And the courts therefore focus not on physical control over victims, but on whether a state exercise effective regulatory control over major emission sources, and whether the harmful consequences were scientifically foreseeable, and whether the state failed to exercise due diligence. I think it's one way forward. And also, I think that the climate crisis reveals weakness, not because the international law lacks relevant rules, but because existing obligations remain still fragmented and enforcement mechanisms are often insufficient. but international law contains duties of prevention, cooperation, due diligence, and protection of human rights. So the challenge lies in translating these obligations into measurable national action and effective international accountability. So this is just, I will let.
That's great. Thank you very much.
That's true.
Perfect. I think it'll be a bit difficult for Professor Akagan to respond, so I'll turn to Professor Kyriazi.
Yes, thank you. And I was reading the questions on the chat, and I recognize the frustration that I see in my classroom when I teach public international law. That it can be when we teach climate change and climate law, but it's also the same when we teach about conflicts and the use of force and so on. So we want international law to bring in, as someone from the audience said, a compelling action. But the international legal order that we have is not the perfect one, but it is probably the best we can. But there is always a tension between state sovereignty and maintaining a peaceful international legal order. We're not doing great lately, but we have been doing quite well post-World War II. So what I would like to say is that it takes time for international law to shape responses. So I would go back to Professor Sumudu's remarks at the beginning of this session that said that for lecturers and for students, what I would think is mostly should be our focus is to educate students and colleagues, lawyers, policymakers early on to be aware of the challenges and of the tools that we have and the mechanisms that we have so that these can be implemented. We should not just wait for the international legal order to just deliver, the silver bullet and solve the problems, because that is not really going to happen, because that's not how international law is shaped. But we can move from advisory opinions to action. And this is the first step. And we will see international law and general international law being shaped starting from advisory opinions. It's just not going to happen immediately on a flash.
Thanks. And the judge from the European Court of Human Rights, Anya Sivit, to some extent answered that, saying, well, they are political bodies. His job it is to implement this. And, and what she didn't say, but was probably thinking was, the politics is failing, so the question should be, why is politics not delivering what the international law is determining? Perhaps Professor Morgera, do you have
Yeah, maybe I'll reply to the question around Caribbean states, because I think it can help us think also about other countries and regions. And I had a country visit last year in Dominica, where I think we really discussed this question. How do states, and particularly least responsible states for climate change, engage with human rights, and why? And one of the challenges is seeing environmental human rights defenders as partners as opposed to troublemakers. And I think moving from that understanding that the most affected human rights holders, which may criticize governments, are actually doing it from a place of understanding of what will be the most meaningful climate solution for most affected countries. And what that means is then shaping the requests from SIDS in terms of international cooperation, as well as shielding and regulating foreign companies who may come in for solutions that are actually going to be very harmful, be that fossil fuels or others. And I think that connection is really the game changer. And it was interesting to see after very few months after my country visit, there was already a Caribbean-led forum discussing how engaging with human rights can support Caribbean-led climate justice, particularly in conversation with climate funders and others. And I think that's been a really beautiful generative process. Of course, we're still with many tensions at the national level, but a lot that can be learned also for national domestic processes.
Thank you. Thank you. Next to Professor Boyd.
Yes, just very quickly, one thing that hasn't been mentioned today is the fact that air pollution kills between 7 and 8 million people every year, and that's a result of burning fossil fuels, and also people living in poverty who have to burn fuel within their homes in order to cook and heat their homes. So tackling that is something that will produce, and one of the questions was about, grassroots communities and local benefits. Every time we manage to close down a coal-fired power plant, the benefits are incalculable for the communities who live near that power plant. And the second point I want to make is that the fossil fuel system, which seems insurmountable today, really only benefits about 10% of the world. And the other 90% of us are the ones who are suffering terribly from the climate crisis and who stand to benefit from the transition to renewable energy. And so we really need to work not only on the law, but on building a global movement that is based on our collective interest in a livable planet and takes down the 10% who are holding us back from that future that we all desire so badly. So not just litigation, not just legislation, but building that global grassroots movement to overturn the system. Thank you.
Thank you, Professor. Thank you to all the speakers. The Zoom is going to may shut automatically in a minute. So thank you, everybody. And the next panel, please join us for the next panel, Plenary 2, on human rights in business, trade, and investment. Of course, we'll be continuing the topics covered here today throughout the course of the day. Thank you, everybody. Really appreciate you joining.